In this particular instance, we immediately requested a copy of the court application and a copy of the court order in order to see on what basis SARS had in fact obtained the search and seizure warrant. And this ties in with the fundamental constitutional right in terms of Section 33 of the Constitution that entitles all taxpayers to just administrative action. And just administrative action specifically entitles persons whose rights have been adversely affected by an administrative action, which was the action to conduct the audit in the first place, that they have the right to be given written reasons, and the written reasons under these extreme circumstances would in fact be set out in the application to the court. The legal representatives of SARS summarily decided that they were not in a position to do so and had no duty to do so, and actually stated to the legal representative that the taxpayer would have to bring an application to court in order to obtain, or ask the court's permission in order to obtain a copy of the warrant, the warrant's application, and as well as the court order, which of course is absolutely nonsense and incorrect. And in addition to that, a debate was entered into with the officials concerned, and the legal representative said, well, we would be entitled to it in any event by making application in terms of the Promotion of Access to Information Act, and to which they said that particular request will definitely be denied by SARS, and that the only remedy available to the taxpayer is to approach the court for a copy of that application and order. So really the taxpayer was denied at a very crucial time that this particular warrant of search and seizure was being executed, to one of their fundamental rights, which was the right to be given written reasons. Now, the execution of the search and seizure warrant took place, proper inventories were drawn up, and immediately a day later an urgent letter was dispatched to the legal representatives of SARS requesting specifically adequate reasons for this particular audit and for the execution of the search and seizure warrant. Now, you must remember, this search and seizure warrant is not in terms of any criminal provisions of the Criminal Procedure Act or any specific criminal provisions in the Tax Administration Act. It is the most draconian step of the three. The first, as I said to you, is to request information from the taxpayer in the form of relevant material, then to attempt to engage with the taxpayer by means of asking them questions, then going to an inquiry, and as a last resort to execute a warrant of search and seizure, unless of course there are very, very special circumstances, and that is that there's a concern that the taxpayer is going to destroy information, or that the taxpayer is a particular flight risk. None of those circumstances existed here. The taxpayer shareholder had already been overseas for a period of time, attending a family function, and certainly there was nothing untoward about this, and the SARS officials were informed when the warrant of search and seizure was being executed that the shareholders would return after the weekend. The family engagement that they were going to was taking place on the weekend, and there was certainly no indication that the shareholders were going to be a flight risk of any sort, and also that there was any indication that any of the relevant material was going to be destroyed or gotten rid of by the taxpayer representatives that were present in South Africa. So there were no reasons for the absolute urgency of the execution of this search and seizure warrant. So that, of course, comes into question. And what was most disconcerting about the facts that unfolded in this particular instance, after that letter was sent to SARS, SARS simply did not respond to that letter, and then invited the taxpayer, and in this particular case with the taxpayer representatives or legal representatives, to attend the opening of the boxes in order for SARS to start looking at the information that in fact they had now taken away from the premises. And a letter was sent for those parties to go to, in this particular case, Megawatt Park, which is just north of Johannesburg. They arrived there. The officials had given the wrong address. The actual opening of the boxes was going to take place in Pretoria. In any event, a few phone calls took place, And it then became apparent to the SARS officials, who incidentally had been at the search and seizure on the Thursday, and they were now being spoken to on the Monday. They had actually seen the legal representative present at the execution of the search and seizure warrant on Thursday, and now that there was a concern about the legal representative being present at the opening of the boxes and everybody was at the wrong address, the legal representatives of SARS turned around and said, well, we require a copy of the power of attorney. Now, it is customary that when you represent a taxpayer, you have the taxpayer sign a mandate to authorize you to act for and on behalf of that taxpayer, so that SARS knows that you are in a position to negotiate with them and talk to them, and SARS are not breaching their secrecy provisions. So it was very clear that that had taken place, and a copy of that was actually then emailed through to the SARS official. The SARS official then decided that the mandate, which actually contained the wording of a classic power of attorney, was not in the form that he wanted it to be in. And he wasn't satisfied with the content of the power of attorney. And this was really a question of form trumping substance. And he then simply refused to enter into any further discussions with the legal representative, and simply then phoned the managing director, ignoring the taxpayer's legal representative, and thereby transgressing a third fundamental constitutional right, and that is the right of a taxpayer to choose and be represented by a legal practitioner, and to be advised of this particular right. In fact, instead of advising of them of this particular right and saying to them, listen, you need to have your attorney or your legal representative present, they simply were concerned about forging ahead, opening the boxes, and continuing with their particular investigation of the relevant material that had been seized, and were not concerned about the rights of the taxpayer. So there were three fundamental rights that in fact had been encroached. First and foremost, there had been the intrusion of the taxpayer's right to privacy, not in the least intrusive manner, in the most intrusive manner, which already makes it unlawful. Secondly, the adequate reasons were not given to the taxpayer for the execution of the search and seizure warrant, despite at least two requests having been made, one at the search and seizure and one in an urgent letter addressed to SARS. And then thirdly, in terms of section 35, subsection 3, subsection F of the Constitution, the taxpayer was denied the right to be legally representative at a crucial time of the opening of the boxes and the copying of the relevant electronic data from that which had been removed from the taxpayer servers.